Misinformation Part 4. Let's talk about it. Alright, it has come to light that a little elucidation is needed for this old 3-minute video that I made almost a year ago. So let's get into it. Federal Reserve notes value for contracting. Even though modern money mechanics says that paper currency has no value as a commodity, it does say that it has value for goods and services. And 31 U.S.C. 5103 labels it legal tender for all debts, charges, and taxes. But you can waive all of that info because the foundation of truth is this, that the people that created it say it has value. It's their property. If you create your own currency, you get to dictate what the value is, but ultimately, it still falls down on whether or not a recipient finds it valuable. For instance, have you ever been to a place and they have that cards only accepted sign? How valuable are your FRNs there? In the United States Inc., you're playing on someone else's game board, okay? And you have to understand the rules. They typically use digital units for contracts as 92% of the world's currency is digital. I also have a video on how acceptance for value is old school tech as well that you can check out. UCC1 financing statement. So remember that each of the several sovereign states is classified as a nation, and international law is a set of rules and principles governing the relations and conduct of sovereign states with each other. The sovereign states came together and they made a pact called the United States to regulate and govern commerce between each nation state. The USC and UCC is just that. This is why whenever things are done that crosses state lines, it invokes that federal international codes and statutes. Currently, the UCC in whole or in part has been enacted and codified in all 50 states, the District of Columbia, Puerto Rico, the Virgin Islands, and other U.S. territories. There are worldwide UCC equivalents, but we're going to focus on the UCC1, usually called a UCC1 form. Article 9 of the Uniform Commercial Code governs secured transactions. It provides a mechanism whereby a secured creditor can perfect their security interest in a debtor's assets by filing a UCC1 financing statement. Perfection of security interests can be obtained through a UCC1 financing statement, purchase money security interests, and through possession/control. However, there are some people that believe filing a UCC1 on the U.S. citizen, which is a corporation that they underwrite, will ultimately give them control over it and access to funds. This is known as the SBC process, which means Secured Party Creditor process or redemption process. In fact, I have an entire 24-week course on the SBC process on my website for free for anyone who wants to look at it at their leisure. I originally paid $1,200 for it 9 years ago when I went through it and then finally realized that it's a fruitless endeavor. Because of the uprise of SPC, UCC filings, the NASS has actually released an entire strategy guide for fraudulent UCC1 filings. Here they say straw man filings under a complicated scheme known as redemption theory is where people believe the federal government creates a straw man account at the U.S. Department of Treasury representing the monetary worth of each citizen. People believe a UCC financing statement allows them to secure an interest in their straw man account and gain access to secret account holding these funds. This process is sometimes referred to as freeing money from the straw man. The name of the secured party, the physical individual, is often spelled with initial capital letters only and a comma or semicolon before the surname. Example, John Dash Robert semicolon Doe. This is done because you can't actually have the same entity name for the debtor and the creditor and think that it's even going to fly through a UCC filing office. Several pre-filing and post-filing approaches are currently available, along with the NASS IACA approach that include strong criminal and civil penalties for those who file bogus UCC claims. Not only can you go to jail for filing an unauthorized UCC1, but in this, CSC released fraudulent UCC filing remedies by state. This is where you can look up the penalties for each state for bogus filings. For example, here in my state in Virginia, it is a Class 5 felony. So, what's bogus about all this, you might ask? The U.S. citizen is a creation of the state. They created it, so they get to control it. We are the authorized representatives, the underwriters, that get to use it, not control it. And I made this video. It's a more in-depth view on the SBC process if you want to look at it. Some say they are just leaning up their labor on a UCC1, and the straw man does not exist without labor. Well, if that's the case, what labor was provided for the first 17 years after its creation? If you are just leaning up your labor, why are you putting the straw man as the debtor if it's just your labor? I have also witnessed many teachers go to jail for the creating of bonds that they are not authorized to do. let's look at a labor lien. Number 3, a labor lien, aka mechanics lien. A mechanics lien can be known by many different names depending on the nature of the property or the services or goods provided, such as artisan's lien, a chattel lien, a construction lien, a garage man's lien, a laborer's lien, a supplier's lien, a design professional's lien, and a material man's lien. A mechanics lien is a statutory lien secured by real or personal property or labor or materials used to improve, maintain, or repair property. Okay, so what labor is used to improve or maintain or repair what property when you are leaning up the straw man as the debtor? Second, the straw man has 4 liens on it before you even start using it. It has a state lien, a federal lien, a social security lien, and a Medicare lien. Have a look at lien priority charts before starting to lien something up so you have some knowledge. Number 4, equity is the highest form of law. So let's have a look at why that is. Okay, this comes from a Dictionary of Law, first edition, 1891, free on my website. First, we're going to read about common law. Common law, as distinguished from equity law, it is a body of rules and principles, written or unwritten, which are fixed and immutable authority, and which must be applied to controversies rigorously and in their entirety, and cannot be modified to suit the peculiarities of a specific case or colored by any judicial discretion, and which rests confessedly upon customs or statutes as distinguished from any claim to ethical superiority. Now, that's a pretty powerful tool to use right there, right? I agree, and it has its place. However, now let's have a look at equity. As old rules become too narrow or are felt to be out of harmony with advancing civilization, a machinery is needed for their gradual enlargement and adaptation to new views of society. One mode of accomplishing this objective on a large scale without appearing to disregard existing law is the introduction by the prerogative of some high functionary of a more perfect body of rules, discoverable in his judicial conscience, which is to stand side by side with the law of the land, overriding it in case of conflict, as on some point of title, inherent superiority, but not purporting to repeal it. Such a body of rules has been called equity. You should also read John Bouvier's quote on how law is nothing without equity, and equity is everything without the law. And he wrote a whole bunch of dictionaries. All right, number 5, belligerent claimant. Belligerent is inclined or exhibiting hostility or a combative temperament, waging war, carrying on war, etc. When referring to being a belligerent claimant, this whole saying right here is completely misconstrued and used out of context. It comes from United States versus Johnson, opinion on February 26, 1947. This is where a judge did not clearly indicate that the defendant was standing upon a right against self-incrimination, but indicated that he was standing upon the right of an attorney not to disclose the confidential communications of his clients. The guy had already testified and the attorney had already produced records on previous proceedings. Then he suddenly figured out later that his testimony and records was going to be self-incriminating, and he wanted to withdraw everything and stop his attorney. So basically what happened was the judge was trying to tell him, it's too late. You can be mad and belligerent and all that and try to stake your claims and rights, but you have already lost. He goes on, if petitioner desired the protection of the privilege against self-incrimination, they are required to claim it. United States versus Minaya. The privilege is deemed waived unless invoked. United States versus Murdoch. A petitioner's claim on the privilege against self-incrimination was pure afterthought in this case. The judge isn't in there telling the guy that, yeah, you got to fight for your rights. Yeah, it's good to be a belligerent and all this and stuff. He's telling the guy that you've already testified some. You've already produced records some. You have an attorney representing you. You have to be belligerent in order to even get to talk because you're being represented. But you've already incriminated yourself substantially. And the judge is basically telling him this, it doesn't matter. You've already lost the case. And when you look up, anytime a belligerent is mentioned in law, it's not good. I mean, honestly, I've yet to have somebody show me a good case law where being a belligerent has actually won or been basically a fruitful endeavor. Let's look how well that works. Here in the United States of America, plaintiff versus Ryan Creighton Doak, the defendant in his filing, Mr. Doak, referred to himself as a belligerent claimant, appearing sui juris in court, engaging in behavior constituting serious and obstructive misconduct. His pro se status will be revoked and an attorney will represent him at trial. See Ferretta versus California. Also stating that the trial judge may terminate self-representation by a defendant who deliberately engages in serious and obstructive misconduct. See also United States versus Engel. His motion was denied. So it is my personal opinion, okay, that the last thing you would ever want to do is wage war against your public servants. They have aircraft carriers, armies, tanks, and machine guns. Yes, we all go through different stages and emotions when coming to the realization that the U.S. citizen is a corporation and the U.S. is a corporation. And the whole public system is smoke and mirrors. It's a scam. But that scam is designed the way it is to keep everyone in lock for a reason. But through self-education, you can understand the systems at play, and that facade just melts away. We all have unalienable rights that goes without saying, all right? But it is advised to enforce them if they are ever trespassed upon. So here's an interesting side note. The case where the affidavit of Walker F. Todd was used, that guy actually lost the case against the bank, even though Walker F. Todd explained on the record that it is our signatures that create an asset on the bank's books and no money is even loaned out. That shows you our legal system operating in the public courts right there, how well it is. Whenever trying to discern things, it is very important to assess a tree by its fruits. What are their underlying motives? I am selling nothing, and I give freely of my own volition to enlighten the unified conscience. Now, however, if I was sitting here and telling you on one hand that the Federal Reserve notes are completely worthless, but pay me $50 in FRNs a month in perpetuity, and I'll show you how to get $100 million from your straw man, I would say that is a huge red flag if you ask me.